So welcome to our constitutional law class. Last time we concluded discussion of rule of law, and we did emphasize that the concept of rule of law, separation of powers, constitutionalism, all of them are complementary. They are not mutually exclusive. In other words, it's not the case that if you are talking about constitutionalism, then only constitutionalism. And separation of powers and the rule of law must remain somewhere. No. All of them, as you notice, they are overlapping in terms of what they emphasize, in terms of what they seek to achieve. And all of them, considered closely, seek to ensure that we have governance arrangement or architecture which safeguard the liberty of the governed, the freedom of the citizenry. And it seeks to achieve that by guarding against over-concentration of power in just one entity, or by guarding against arbitrariness or capriciousness as far as exercise of powers of governance are concerned. So those are the things which these concepts, constitutionalism, separation of powers, rule of law, seek to achieve. And there's a related concept, which I would say is pivotal for all the other three that we're talking about to actually make sense. That is judicial review and its related principle of judicial independence. So tonight class, we are going to explore the meaning of judicial review, try and understand how judicial review has evolved historically, and also contextualize it in Ghana's constitutional law, especially the period before the 1992 constitution. What was the situation like as far as judicial review is concerned, and the period that we had the military intervening in our politics. Was there any judicial review during the military rule? So we will be exploring that as well. And of course, we will look at how our 1992 constitutional architecture has actually conceptualized and positioned judicial review as well as judicial independence. And we will reflect on a theoretical concept, judicial activism on one hand, and judicial restraint on the other hand. We will try and unpack what each of them means, and then you'll be invited to think through whether what has been going on in Ghana through the lenses of the various cases that we have, whether you will say that judicial activism is more prevalent or judicial restraint is on the ascendancy in Ghana. And of course, we try and pull everything together that having said and exploit all this, what is the end of the matter? Just as the Kohelet or the book of Ecclesiastes will say, so relation to constitutional law, so having learned all that, how relevant is judicial review in constitutional law, so to speak? So that is the roadmap which we are going to travel along. So to start with, judicial review, in its most comprehensive sense, includes the power of the judiciary to invalidate legislation as unconstitutional and to control the legality of administrative action. So if you look at it, judicial review is doing two main things. On the one hand, the power of the judiciary, usually the apex court, the Supreme Court, or in some jurisdictions, they have what you call like the Constitutional Court, like South Africa. You go to Germany, and then you go to France. They usually have like a dedicated court, which is endowed with teaching. They have like a dedicated court, which is endowed with making pronouncement as whether something is constitutional or unconstitutional. So that is one. And then we also have the other side of judicial review, where you make a determination as to legality of administrative action. So that is the other side of judicial review, as it were. Now, if you look at Justice Brobbey in his well-received book, Trial Courts and Tribunals of Ghana, he will make the following observation as far as judicial review is concerned, and I quote, "Judicial review is the power of examining or revising with a view to correcting the decisions or orders of other branches of the courts, government bodies, or public institutions." And then he continues, "In contemporary practice, judicial review is used when referring to the exercise by which such decisions are examined or revised by the issue of orders of certiorari, prohibition, mandamus, quo warranto, and habeas corpus." I mean, simply put, Justice Brobbey is reinforcing the point that we have been making, that judicial review refers to one of two things. You make a determination as to whether the organs of government have actually stayed within their constitutional remit, the boundaries delineated for them by the Constitution, or they have exceeded same. So that is one. Or you want to find out whether various public institutions, administrative bodies, have exercised their power properly within the remit of the law. And where that is not the case, and they have actually overstayed their remit or their boundary, then you deploy the appropriate remedies, such as certiorari, by which you seek to quash or cancel or nullify the particular decision or action, or prohibition, by which you seek to restrain whoever has a certain role or power from going ahead to perform that role or exercise that power, or or mandamus, where a person has been given authority, but he or she is not exercising it. Then you deploy mandamus to direct him or her to exercise the authority which he or she alone can exercise. And then quo warranto, where a person is purporting to exercise authority which he or she does not have under the law, and you seek to challenge the basis of the authority or the jurisdiction which he or she is purporting to assume. So that is quo warranto. And then habeas corpus, subjacendum habeas corpus. That is where you get an order directed at the person, detaining or keeping another person without authority to come and show cause why the person that he or she is detaining should not be released. So these are some of the ways in which the court may achieve judicial review. So the point has been made that the concept of judicial review is inextricably linked with the concept of rule of law. We have come to know rule of law to mean government of laws as opposed to government of men, or that government should be by laws and not by men. And in that regard, judicial review is seen as a very complementary future, because the question will arise: is it possible to believe in and guarantee the rule of law in the country, but yet deny the courts the power to determine the constitutionality of acts of other branches of government? Is it really possible? Does it make sense? Is it logical? In one breath, you say that yes, you have a governance or constitutional system in which everything is according to law, according to the principles of the law, and yet you do not create entity as in courts that are clothed, that are vested with power, with authority to make determination as to whether the various branches or arms of government have actually stayed within the scope of the authority which has been granted them or not. And that is why we make the point that the concept of judicial review necessarily stems from a belief in the rule of law. And as I've told you, is also very much linked to the idea of separation of powers and also constitutionalism. So these are all what we call interrelated or interlocking constitutional theories or doctrines or concepts, name it. Yeah, but as a matter of fact, most countries that have written constitution, the constitution will invariably provide for judicial review. The constitution will clothe the courts with the jurisdiction or the mandate for making a determination as to whether other arms of government have actually stay within the remit of their power. My own teacher, the respected Professor Kofi Kumado, has identified two forms or two ways in which judicial review manifests. The first situation occurs in a constitutional scheme in which the courts have or exert the power to declare an enactment of the legislature as unconstitutional. So usually, the exercise of such a power is granted in a written constitution, which is not very easy to amend. And for that matter, it tends to be a rigid constitution. And as we noted from the introductory class, a rigid constitution does not mean that it cannot be changed. It can be changed, except that you have to go through laborious, complex process, just as we have in the entrenched provisions of our Constitution. Then the second type is where a court resorts to strict interpretation of a piece of legislation. That is to say, the court, while professing to be interpreting the enactment, puts on the legislation an interpretation that frustrates the legislature's intention, as it were. Well, these are his ideas, but what he has said is equivalent of what we call judicial activism and judicial restraint. We come and say more about that in the course of this class. So, therefore, we need to draw the line between judicial review understood in constitutional law sense and judicial review understood in administrative law sense. In constitutional law, judicial review deals with constitutionality of acts of government, legislation, and even the citizenry to a large extent. So in constitutional law, when we are talking about judicial review, our main interest, our main understanding is to find out whether various entities, various functionaries, various branches or arms of government or branches, have they complied with the letter and the spirit of the Constitution? So that is the essence of judicial review in constitutional law. On the other hand, in administrative law, when we talk about judicial review, we are concerned with the legality of also administrative bodies. Administrative bodies, have they stayed within the scope of their authority? Where they have acted outside the scope of the authority, they have exceeded their power. We say that they have acted ultra vires. Ultra vires means that you have acted in excess of your power. Or they have acted even contrary to the law. So that is the focus of judicial review and administrative law. So for example, maybe Lands Commission, you have applied for registration of an interest in land, and they have done something or failed to do something against the law or in excess of the law. You will need judicial review action against them. But this kind of judicial review will essentially be judicial review in administrative law sense, as it were. Or you've applied for passport from the passport office, and you've done all that needs to be done. There's still no issue to you. That is a judicial review action you need against them. So the mandamus may be issued against them, as it were. So the distinction boils down to an understanding of the difference between constitutional law and administrative law as separate disciplines. So in your Ghana legal system and legal method, and of course also in the introduction to constitutional law class, we actually talk about the distinction between constitutional law on the one hand and administrative law on the other hand. So judicial review in administrative law is part of the broader idea of judicial review that constitutional law tries so hard to achieve. So if you like, judicial review in administrative law is a subset of judicial review in constitutional law. So if you were on the bus or trotro from Adenta to Circle, and someone asks you, or from Atoli to Kagetia, and someone asks you, you're a student of constitutional law. This concept of constitutional review, of a judicial review, as far as constitutional law is concerned, what does it really entail? What does it encompass? Well, 4 points may be canvassed. That judicial arm of government is the one that settles dispute between the other branches, and by necessary implication among all 3 branches. So judicial review enables inter-branches dispute, if you like, to be managed or determined. And not too long ago, we have seen one between the legislature and even the judiciary, who determines what the constitutional position is as far as operations of parliament are concerned. And we saw that not too long ago in Afenyo Markin against the Speaker of Parliament and Attorney General. It places limitation upon the activities of the branches of government by virtue of the power to declare their actions as unconstitutional, if need be. So here, we are still alluding to constitutionalism. The fact that limitations should be placed on what? Those who wield governmental power. So judicial review enables determination to be made as whether the various branches of government have actually flouted the limitations imposed upon them or not. Again, it allows the principle of checks and balances to operate among the branches of government. So, judicial review is one veritable, one potent means by which the judiciary manifests its dimension of checks and balances in the governance machinery, as it were. Yes, Parliament has the power to make law, but the judiciary has the power to make a determination as to whether the laws that they have made conform to the letter and spirit of the Constitution. You take Chapter 6 of the 1992 Constitution, the directive principles of state policy. Certain ideas have been canvassed, and these ideas so these ideas are supposed to guide everybody, the executive, legislature, judiciary, independent constitutional bodies, and everyone. So therefore, where certain legislative or executive policy measures have been formulated and they undermine these aspirations, the judiciary, through judicial review in terms of determining constitutionality or otherwise, will come in. And that is how it manifests its checks and balances. So the judiciary then is a body entrusted with the responsibility of interpreting the Constitution and all other laws. And clearly, the judiciary's mandate to do that emanates logically, intrinsically, inherently from the very existence of the judiciary or the courts vis-a-vis other arms or branches of government. So, making determination as to what the law means, what the Constitution means, is a natural function or natural role of the judiciary or the court. So let's keep that in mind. And then the other point to note is that when we talk about judicial review, we are not talking about appeal. Appeal is different from judicial review. In the case of judicial review, what the court is seeking to do is to supervise exercise of power by maybe the lower courts, or to make a determination as whether certain branches of government have stayed within the remit of their power or otherwise. And that is different from an appeal. So if you take the case of R against Secretary for the Environment, ex parte Hammer Smith and Fulham London Borough Council, the master of the rules at the time, Lord Justice Donaldson, made a comparison in terms of what is expected of a judge in judicial review proceedings vis-a-vis the referee in a football match. And this is how Donaldson MR rendered himself, quote, "In football, the moves made by the players and the tactics employed by the teams are matters entirely for them. The referee is only involved when it appears that some player has acted in breach of the rules. The referee may then stop the play and take some remedial action. But tempting though this may be, it is not for him to express any view on the skill of the players or how you have acted in their position. Still less, following a breach of the rules, does he take over? In teaching. Does he take over one of the position of the players? So too with the judiciary, unquote. So just trying to say that what the referee does on the football pitch vis-a-vis the players when the game is in session is more or less analogic to what the court or a judge will do with respect to judicial review proceedings. But if a statute creates an appeal process for dealing with decisions, it is likely that courts will require for this appeal system to be exhausted first before the plaintiff can resort to judicial review. So where there is a procedure for appealing decision of a lower court, relatively lower court, you must avail yourself of the appeal. Although appeal and judicial review oftentimes are not mutually exclusive, meaning that you can pursue the two at the same time. However, if you look at the trend of jurisprudence, the case law, especially from Supreme Court and all that, the tendency is to say that make use of the appeal process before judicial review, or judicial review should be resorted to in deserving cases, such as errors of law, not errors of fact. So where a judge or a person with authority to make certain decision has committed an error of law, then that is a good candidate for judicial review and not appeal, as it were. Of course, that can also be a subject matter of appeal, but if you are talking about judicial review, we don't talk about errors of fact, we are talking about errors of law. So judicial review is meant to correct improper application of law, not improper interpretation of the facts. And in judicial review, it's not about retrying the case. Appeal is about retrying the case. So in appeal, the appellate court is virtually in the same position as the trial court as far as evidence reduced on the record of proceedings are concerned. In terms of jurisdictions of the courts, we know that we have various types of jurisdiction, but at least a court will have one of various jurisdiction or more. So we have original jurisdiction. So original jurisdiction simply means the power of the court to hear and decide the matter for the first time before any other court can review the matter. In other words, when a cause of action has arisen, and when we say a cause of action, it refers to a factual situation for which the law will give a remedy. So where someone is complaining that his right or interest has been violated, or someone has breached a contract, or someone has done anything. Now, when the person takes up the matter for the first time, the court that it can take to is the court which is said to have original jurisdiction. So original jurisdiction means a court's power to hear and decide the matter before any other court can review the matter. On the other hand, appellate jurisdiction refers to the power of a court to review and revise a lower court's decision. So appellate jurisdiction necessarily presupposes that there has been first hearing or first determination of the case, and someone is aggrieved or dissatisfied and would like an appellate court to have a second look at the matter and reconsider it. We also have what they call concurrent jurisdiction. That is a jurisdiction that might be exercised simultaneously by more than one court over the same subject matter within the same territory. So where the case can be taken up by not only one court, two or more, then we are saying that the courts that are competent to the seize of the matter, to hear the matter, they are said to have concurrent jurisdiction. And usually, courts of coordinate status have concurrent jurisdiction most of the times. You take the High Court, for example. There's only one High Court of Ghana, which sits in various parts of the country. Then we also have what we call general jurisdiction. So general jurisdiction refers to the court's authority to hear a wide range of cases, civil or criminal, that arise within its geographical area. And then we also have what we call the exclusive jurisdiction, exclusive. That is a court's power to adjudicate an action or class of actions to the exclusion of all other courts. So for example, when it comes to interpretation and enforcement of the Constitution, the Supreme Court has exclusive jurisdiction, meaning that the jurisdiction that the Supreme Court has is only the Supreme Court that can exercise it. Then when it comes to enforcement of fundamental human rights and freedom, if we take Article 33 of the Constitution and the Courts Act, you notice that the High Court has been given exclusive jurisdiction. You cannot seek to enforce any of the fundamental human rights in Chapter 5 in the Circuit Court or in the District Court or even the Supreme Court. You have to go to the High Court. Now, the power of judicial review, from our previous discussion, you have noted that it has a long history. We know very well the U.S. Supreme Court decision in Marbury and Madison. And the decision in Marbury and Madison is quite monumental as far as foundation of judicial review is concerned. For the simple reason that if you take United Kingdom, although they have judicial review there, but because they don't have a written constitution, the judicial review which developed there is not in relation to making a determination as whether something is constitutional or not constitutional, as it were. And that is why Marbury and Madison is quite a landmark decision as far as judicial review is concerned. Now, as we just noted, if you look at the history of the common law, we have some old cases which suggest that what we call judicial review long ago was also attempted or by the English court. We have, for example, mentioned the Boham case, a very old case going back to the 17th century. If you look at the report, it was decided in the 1610. And the Boham case Dr. Boham in 1606 was found to be practicing medicine in London without a license. He was summoned to appear before the censors at the London College of Physicians, who had jurisdiction in London over the practice of medicine. Now, an act of parliament gave authority to London College of Physicians to levy fines against anyone who violated its rules, including practicing without a license. Dr. Boham was deemed unfit to practice medicine in London and was ordered to desist or stop from practicing medicine. Dr. Boham flouted or disobeyed this order and was arrested and placed in the custody of the censors. And the case was eventually brought before the Court of Common Pleas because Dr. Boham claimed that his continuous detention amounted to false imprisonment. Now, in defense, the college relied on its status of incorporation, which authorized it to regulate all physicians in London and punish practitioners not licensed by them. Their enabling act also entitled the college to 1/2 of all fines imposed by it. So if they imposed fines, they were supposed to retain 50% of whatever fine that they have imposed. Just like the judiciary, at the moment, they are allowed to retain at either I think 15% or 20% of fines, which are imposed for various criminal offenses in the country. And then the rest will go into the consolidated fund. So it's a similar situation existed at the time of the Dr. Boham case in the 17th century. Now, Chief Justice Coke, who presided over the case, was of the view that because the college censors were entitled to receive a portion of the fine they imposed on Dr. Boham, the statute made them prosecutor, plaintiff, and a judge in the dispute. Because they are enforcing the law, they are also supposed to benefit from whatever funds which will be levied. And so that was the problem Chief Justice Coke had. And this is how he rendered himself, quote, "The censors cannot be judges, ministers, and parties. Judges give sentence or judgment. Ministers make sermons, and parties have moiety, that's half of the forfeiture, because no person may be a judge in his own cause. And one cannot be judge and attorney for any of the parties. It appears in our books that in many cases, the common law will control acts of parliament and sometimes adjudge them to be utterly void. For when an act of parliament is against common right and reason, repugnant or impossible to be performed, the common law will control it and adjudge such act to be void." So this, dictum of Chief Justice Coke in the Dr. Boham case, as you notice, strike at the heart of what will come to be known as the judicial review in a sense. So we move from the 17th century, we come to the 18th century, that is Marbury and Madison in the US. And Marbury and Madison, we know the facts already from the various topics that we'll be discussing. And it is significant for a number of reasons, three main. Marbury and Madison was the first time the SCOTUS, that is the Supreme Court of the United States, declared anything as unconstitutional. SCOTUS, that is Supreme Court of the United States, had not yet made any authoritative pronouncement as whether something was constitutional or unconstitutional with respect to the federal constitution vis-a-vis the various arms of government. Again, the case established the concept of judicial review in the United States, that court may oversee, scrutinize, and nullify actions of another branch of government. And thirdly, the case helped define checks and balances in the American form of government. So what were the facts in Marbury and Madison? As you recall, in 1800, that is the very beginning of the 19th century, Thomas Jefferson defeated John Adams, just as Donald Trump defeated Kamala Harris. So defeated John Adams in the presidential election to become the third US president. Now, before Jefferson assumed office in April 1801, the outgoing president, John Adams, and Congress had passed a legislation known as the Judiciary Act of 1801, and they sought to amend the then existing legislation, Judiciary Act of 1789. Now, acting pursuant to this new legislation, several new judges called Justice of the Peace were appointed. So William Marbury was one of the several judges who have been appointed by this outgoing government. Unfortunately for Mr. Marbury, his commission simply refers to warrant. You see, when you become a judge, even in Ghana, right? In Ghana, if you're a judge, the most important document which makes you a judge, we call it your warrant. That is judicial warrant or warrant of office. And it is signed by the president, which confers on you the power to exercise judicial power, as it were. So, Mr. Marbury had not been given his commission, that is his warrant, before the outgoing president, President Adams, exited office. And eventually the new president, President Jefferson, took over. Now, interestingly, the outgoing Secretary of State was John Marshall, and he had been appointed Chief Justice. So he was previously Secretary of State. Now has become like the Chief Justice. Now, President Jefferson instructed the Secretary of State, that is a new one, James Madison, who had taken over from John Marshall. John Marshall was the Secretary of State. When his government lost, he had to leave office, and then quickly he had been appointed Chief Justice by the outgoing government. Now, President Jefferson instructed the new Secretary of State, James Madison, not to deliver Marbury's commission, his warrant of office, the instrument which makes him a Chief Justice or a judge. So he had been instructed not to make it available to him. So Marbury brought an action in the Supreme Court for an order of mandamus to issue to compel the Secretary of State to perform his public action, that is, deliver the commission, because the Secretary of State who could deliver the commission or the instrument of appointment. Now, John Marshall had assumed the role of Chief Justice at the time the matter came before the Supreme Court for adjudication. And the issues which the court had to deal with were the following. First, whether or not Marbury had a right to commission Was Marbury supposed to give in the commission, the instrument of office? 2, whether or not the laws of US provided a legal remedy for Marbury. If you are supposed to be given an instrument of office, if not be given, do you have any remedy under the American law? And 3, whether or not mandamus could issue from the Supreme Court. The court concluded that the Judiciary Act, which purported to modify or extend the original jurisdiction of the Supreme Court, was in excess of the powers of Congress. And then since there was a conflict between an act of Congress and a provision of the US Constitution, the court concluded that on the basis of the supremacy principle, the latter must prevail. That is, if there's a conflict between act of Congress, the legislature, and then provision of the Constitution, then the provision of the Constitution should supersede or should prevail over the offending provision in the Act of Parliament. And this is how Chief Justice Marshall beautifully delivered himself, quote, "It is emphatically the province and duty of the Judicial Department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If 2 laws conflict with each other, the court must decide on the operation of each. So, if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the law, the court must determine which of these conflicting rules govern the case. This is of the very essence of judicial duty. If then the courts are to regard the Constitution, and the Constitution is superior to any other act of the legislature, the Constitution and not such ordinary act must govern the case to which they both apply." Unquote. So you notice how, in a very beautiful and succinct way, Chief Justice Marshall was articulating that if you look at the logical arrangements within our Constitution, our constitutional system, it follows necessarily that where there's a conflict between the Constitution and any other law, because the power to make the law is even derived from the Constitution, then the Constitution must remain supreme. And if the Constitution is to remain supreme, what it also means is that it must be the job of someone to say so. And whose job it is? It is the job of the judiciary, the Supreme Court. We will now look at the judicial review in Ghana before the 1992 Constitution came into being. And we can trace judicial review to the period before independence, even as was the case with all British colonial territories. You know, there was a highest court we call the Privy Council, what was in the UK. And the Privy Council served as the final appellate court and supervisory court over all adjudicating bodies in the overseas empire, the then British Empire. Now, the power of our courts to strike down legislation as unconstitutional is not derived from the common law. So let's keep that in mind. Of course, the common law, if you look at the Chief Justice Coke, in the Dr. Bonham's case, you notice that the judicial review was being referred from the common law itself. And again, what pertains in Ghana is in clear contrast with English conception of parliamentary sovereignty. You might have heard of the saying that the British Parliament can do all things except to turn a man into a woman into a man. And even now that we have this gender surgery, I'm sure now that observation may not even be 100% accurate. But the significance of that saying to what we are discussing is that Parliament, the king or the queen in Parliament, was considered, sovereign and supreme, meaning that they could make all manner of laws. And for that matter, the court did not have the power, if you like, to strike down Act of Parliament as being constitutional or unconstitutional, as it were. So the judicial review, which the courts in the UK exercised, was mainly in relation to inferior adjudicating bodies, as well as other administrative bodies, as whether they have acted in ultra vires, in excess of the powers they be granted or not. And if you remember your sources of law in Ghana legal system, you have learned delegated legislation or subsidiary legislation. And as you know, the power to make delegated legislation emanates from the Parent Act. So where, for example, legislative instrument or statutory instrument or constitutional instrument or bylaws have been made ostensibly under particular legislation. And if upon a closer scrutiny, it is discovered that it actually contravenes the parent legislation, the enabling legislation, then that is ultra vires. And in UK, judicial review will be triggered for it to be struck down as ultra vires, as it were. Now, judicial review has been, part of our jurisprudence from the very beginning, even independence and post. If you look at, for example, the order in council. So the order in council is the law which was made by the imperialists, the colonizer, British colonizer, regarding how governance was organized in Ghana. So if you look at the 1957 independence, which was contained in the order in council, especially section 31, subsection 5 thereof, it says, among other things, quote, that the Supreme Court shall have original jurisdiction in all proceedings in which the validity of any law is called in question. And if any such question arises in a lower court, the proceedings in that court shall be stayed, and the issue transferred to the Supreme Court for decision. So you notice that even under 1959 Independence Constitution, questions of constitutionality, questions as whether something is in violation of the Constitution or not, were made exclusive preserve of the Supreme Court. And if there was a matter pending before any lower court and an issue arose as whether it was constitutional or unconstitutional, reference was supposed to be made to the Supreme Court. And the proceedings before the lower court was supposed to be put on hold or suspended until the Supreme Court had returned its opinion regarding the constitutional issue referred to it. So if you look at cases like Wari and Ufurata, you see examples. But the power of the court was limited. So if you look at section 31(1) closely, they say that subject to provisions of this order, it shall be lawful for Parliament to make laws for the peace, order, and good government of Ghana. Meaning that when it comes to peace, order, and good government, Parliament more or less had the ultra power. And it was in the context of this provision which Parliament made the infamous Preventive Detention Act. So the Preventive Detention Act is a law which was not made in the system. It was made actually pursuant to the Independence Constitution in the name of Parliament making laws for peace, order, and good government of Ghana. So if you look at the case of Ladan against Attorney General Naba, we discussed it when we were discussing constitutionalism. You will remember that there was a deportation order made under the Deportation Act of 1957. And the plaintiff, Ladan, was supposed to be deported from Ghana. So consequently, he mounted a suit seeking a declaration to the effect that the Deportation Act could not be applied to him because, in his view, he was a Ghanaian by birth. Now, while he was challenging this matter in court, before the court had even decided, Parliament quickly passed a new legislation called Deportation into bracket Osman Laden and Amadou Baba Act, 1957. And under this new law, the Minister of Interior, of course, Kobodu Say at the time, could order the deportation of the two named individuals from Ghana. Again, Section 4, Subsection 2 of the legislation, Deportation of Maladin Amadou Baba Act of 1957, sought to terminate any proceedings in any court instituted for the purpose of challenging the validity of any deportation order made against persons affected by the act. So the question which the court had to deal with was whether or not the legislation which had made was ultra vires the Constitution. In essence, the court was called upon to determine the constitutionality of an act of what? Of Parliament. And you recall what Section 31(1) of the Order in Council, which established the independent constitution, stated that subject to provisions of this order, it shall be lawful for Parliament to make laws for the peace, order, and good government of Ghana. So keep this in mind. And this will influence how the court will go about it. So Justice Smith, who presided over Laden against Attorney General, held as follows. Parliament has plenary powers to pass legislation under Section 31(1), and that it is not for the court to inquire into such legislation, and that the validity of any act can only be challenged in a court of law on the ground that it infringes Section 31. The words peace, order, and good government without qualification give to any country the same plenary powers as are possessed by imperial parliament in England, unquote. So the judge was saying that if we look at the provision in Section 31(1) of the Order in Council, which says that Parliament can make law for the peace and order and good government of Ghana. What that meant was that Parliament more or less had, if you like, parliamentary sovereignty, parliamentary supremacy, just like what pertains in the UK, and they could do any law at all, cannot be challenged in any court. So this was the point being made by the court. Similarly, the case of Balungun against Eduse, we've also discussed that already, so I will not belabor the point. We've discussed that already extensively. Now, if we look at the 1960 Constitution, Article 42, Clause 2, provided that, quote, the Supreme Court shall have original jurisdiction in all matters where a question arises, whether an enactment was made in excess of the powers conferred on Parliament by or under the Constitution. And if any such question arises in the High Court or an inferior court, the hearing shall be adjourned and the question referred to the Supreme Court for decision. So you notice that the first Republican Constitution, that's the 19th State Constitution, is also re-echoing the exclusive original jurisdiction of the Supreme Court as far as constitutional interpretation or judicial review is concerned. And it was against the backdrop of this provision that the well-known case of Rea Koto and Seven others came up. Again, this is a case that we have discussed extensively. And if you remember the case, what the Attorney General at the time, Jeffrey Bain, speaking for the state, and the Venerable J.B. Dankwa, also speaking for the applicant for the habeas corpus. We should go back to the arguments. And you notice that the judicial review under the 1960 Constitution was said not to be comparable with review under the American Constitution because the origin, aims, and objects of judicial review in the 1960 Constitution was said to be peculiar to the form of that Constitution. And the Attorney General in Rea Koto denied that the power of judicial review could not be implied from any universal theory of rights of the court. So you're just simply trying to say that we shouldn't import what happened in jurisdictions like the US, including Marbury and Madison and other similar constitutional ideas into our municipal constitutional arrangements. So whether or not judicial review existed in view of the Attorney General, Jeffrey Bain, must depend on the express terms of the Constitution in question. And so he finally argued that if you look at the 1960 Constitution, was mechanistic. And by this, he meant that the Constitution expressed the general principles and provided the detailed mechanism by which those principles were to be implemented. The Supreme Court, you all know the conclusion they gave, held that the Preventive Detention Act was constitutional. But it went on to limit, and that is a warranting, to limit its power of review to the entrenched clauses. Now, the affected provision, as you read the judgment, they said that they were equivalent to the coronation oath. The coronation oath of the King of England was not enforceable. So in the same vein, the various guarantees or assurances which the president would give by the oath that he takes on assumption of office, political matters which can be enforced through political means and not through the courts. And the court actually narrowed the situation in which parliamentary action could be questioned. And that was a low moment as far as development of judicial review is concerned in our country. And as I said, ultimately they said that Article 13 Clause 1 was not legally enforceable. And again, you also remember the case of ex parte Salifa. So what all that we discussed in ex parte Salifa and the constitutionalism is mutatis mutandis applicable to what we are discussing now. So please go back to it. And also, as part, the two Salifa cases, actually read all of them. We discussed them, so I need to be skipping. Now, under the Second Republic too, we also saw judicial review. If you look at Article 106 of the 1969 Constitution, that's the Second Republic Constitution, The Supreme Court was vested with the power of deciding the validity of enactments or various acts performed under the Constitution. So the Supreme Court was expressly given the power to declare invalid an enactment which was inconsistent with the provision of the Constitution. And you remember what happened in the case of Salah against Attorney General, and also Shalabi against Attorney General. We've discussed them, so we are not going to discuss them here again. What we said are applicable mutatis mutandis. Again, during the National Redemption Council too, we've discussed the case of ex parte of Osuama, in which even under the military rule, you notice effort is being made by the court to try and assert some power of judicial review. And in the case of Kwache against Attorney General, but just before I move on, I think there's a decision. If you read the ex parte of Osuama, in giving the decision, the court made reference to the Maikankan case, an ex parte Adujamfi. The Maikankan case is of interest because the Maikankan case introduced a certain understanding regarding how to manage constitutional issues when they arise before lower court. So the Maikankan case introduced the idea that where an issue of constitutionality arises in the course of proceedings before a lower court, the court needed not to actually automatically stay proceedings and make a referral. It can go ahead and then state what it thinks the constitutional position is. If a party is not happy and is dissatisfied, that party can actually appeal that interpretation. But I must say that if you look at the current trend of jurisprudence, the Maikankan case is no longer a good law in that respect. So let's keep that in mind. Now, another Third Republic Constitution to 1979, we already discussed the case of Kwache against Attorney General, a case by a former Inspector General of Police who was tried and convicted in absentia by the Armed Forces Revolutionary Council Special Court. And he put up the argument that he was never convicted by a court of competent jurisdiction, and he wanted the Supreme Court to grant him relief. But the Supreme Court refused to grant him the relief he sought and held that what took place was akin to a trial, because in view of the Supreme Court, the transitional provision of the 1979 Constitution forbade any court from questioning judicial action taken or reported to have been taken by the FRC. You know what we call the ouster clause, O-U-S-T-E-R, ouster. Ouster clause, these are clauses which are put in legislation to try and deny or deprive the court's jurisdiction. But you notice that Justice Taylor in Kwache gave a very powerful dissenting opinion. And he said that, quote, the idea that any statutory institution, authority, or tribunal or of inferior jurisdiction is outside the control of the judiciary is surely incompatible with the essence and the regime of the democratic system. It undermines the rule of law, it is subversive of orderly government, and is an erosion of the people's liberty. if the AFRC Special Court is uncontrollable, what was the need for the elaborate provision setting it up? Who is it to ensure that its statutory terms are complied with? A capricious or illegal action is not a judicial action and cannot have the appearance of a judicial action. Now, assembling unlawfully in secret in a caucus or as a court and without hearing evidence as approved by law, to administer unlawful secret oaths and to sentence a person has no resemblance to judicial action or purported judicial action. It rather resembles a capricious act or an illegal act, unquote. So Justice Taylor was disagreeing with the rest of the Supreme Court, and he was saying that Kwache was right, that whatever the AFRC Special Court did could not be treated as adjudication properly so called, and for that matter, he had not been tried. But this was a dissenting opinion. We also recall the decision into 4 versus Attorney General. So that was another clear example of the judicial review under that constitutional regime, as it were. But under the PNDC, you remember that PNDC is a regime which has nothing to be celebrated as far as judicial review is concerned, especially so with the blood of the 3 judges and a retired army officer on the hands of Rawlings and his people. Judicial review was absent. There was no proper rule of law, so to speak. PNDC era was largely, an AFRC exercise in lawlessness, abuse of power. And there was, of course, absence of separation of powers. There was no independent judiciary. And what the PNDC sought to do was to do its own convenient arrangement called public tribunals in the name of power to the people, in which people who did not know anything about law were put together and given the power to exercise judicial authority and be administering justice with no reference to serious rules cognizable under civilized justice system. Then we also have, there was also, of course, abuse of judicial process. There were denial of due process guarantees and so many other things. And that is why in the West African magazine, regarding the case of Emmanuel Ohin Obin, dealt with by this tribunal, the public tribunal, the magazine will comment as follows, quote, before it, referring to the public tribunal, was one Emmanuel Ohin Obin on charges of dishonestly receiving and stealing 40 bundles of galvanized goods and 40 bundles of cotton wool. Property of the people, just look at the property of the people. He bore the marks of torture, cracked lower lip, black eyes, and plaster wound on the left temple. His counsel, a blood relative, drew the court's president, Mr. Aiken's attention to the marks and to the caution statement Ohin Obin gave to the police while helping in the investigation. The statement was taken without independent witness. Mr. Aikens angrily rejecting the submission said, so this is a judge who was sitting, helping the military people with the tribunal. And this is what he said, quote, we are in a revolution. Don't you realize that we are not going to entertain any legal technicalities? We have changed the legal system. In any case, the investigator could not have written a fabricated statement to implicate the accused. Please sit down. There are more offenders to deal with, unquote. So you call this justice? You call this proper court? Definitely, this is what we call the kangaroo court system. So Emmanuel Ohin Obin was sentenced to 10 years, and half of that was to be spent collecting human excreta. that is a toilet or defecant. Another half on the Kwamoso oil palm plantation. Now let's look at the situation of judicial review under the 1992 Constitution. Now, as far as the 1992 Constitution is concerned, we need to remember that the Constitution has adopted what we called supervisory jurisdiction, okay? Supervisory jurisdiction, which is used interchangeably with the word judicial review. So if we mention supervisory jurisdiction, we're also talking about the power of the court to do judicial review. And the supervisory jurisdiction is conferred on the Supreme Court and then conferred on the High Court. These are the two courts which have supervisory jurisdiction. But again, in terms of constitutionality, making pronouncement as whether something is constitutional or not constitutional, as we notice, if you look at Article 2 and Article 130 of the Constitution, it is the Supreme Court which has been given that power. And that one is different from exercising general supervisory jurisdiction over all other adjudicating bodies. Now, if you look at the case of Republic against High Court Accra, ex parte Industrialization Fund for Developing Countries, Justice Chum provided a very insightful exposition on this aspect. Quote, whereas the King's Bench division invented the power of judicial review, our High Court acquired the power as part of received law. Our civil procedural rules were copied from the English rules and the substantive law, English. At this time, supervisory jurisdiction was conferred only on the High Court, just as that jurisdiction was conferred only on the High Court in England. Then in 1969, there was a change. The 1969 Constitution of Ghana conferred supervisory jurisdiction also on the Supreme Court. This was repeated verbatim in the 1979 Constitution. The current law is contained in Articles 132 and 161 of the 1992 Constitution, unquote. So if you look at Article 2 plus 1 of the 1992 Constitution, we are too familiar with it. We know it. The provision that a person who alleges that an enactment to anything contained in or done under the authority of that or any other enactment, or B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. So no doubt, Article 2 has actually stated unequivocally, without any ambiguity whatsoever, that any acts, be it enactment, be it an action or anything, which you consider to be violative of the Constitution, go to the Supreme Court for the Supreme Court to make a declaration to that effect. And that was why in NPP versus the Attorney General, the 31st December case, the Supreme Court held, among other things, that, quote, although Parliament had the right to legislate, every such legislation had to be within the parameters of the powers conferred on the legislature by the Constitution, 1992, because under Article 1, Clause 2 of the Constitution, any law found to be inconsistent with any provision of the Constitution should, to the extent of the inconsistency, be void. And once an act was null and void, the president or the executive could be restrained by injunction from enforcing or obeying it, quote. So you look at Article 132, the Supreme Court is giving supervisory jurisdiction over all courts and all adjudicating bodies. And the Supreme Court has the power to issue orders and direction against any adjudicating body. as far as matters of supervision are concerned. And if we look at Article 1 says 1, it will say that unless the context otherwise requires, supervisory jurisdiction includes jurisdiction to issue writs or orders in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto. So we've explained what this means. Now, apart from the Supreme Court, as we have indicated, the High Court has also got supervisory jurisdiction over lower courts and other lower adjudication authority under the High Court. So look at Article 141 of the Constitution. So the articles to pay attention to as far as judicial review and the Constitution is concerned. Article 1, Clause 2, Article 2, Clause 1, Article 3. Article 3 is very important because Article 3 also talks about the consequences of disregarding the orders which the Supreme Court, for example, will make after it has made constitutional pronouncement. The Supreme Court has given interpretation. The Article 3 says that it can issue any orders or direction which the Supreme Court consider appropriate for ensuring that the interpretation that it has given is actually given effect to. And where that is disregarded, even if you are president or the vice president, it can be a ground for removal from office. And if you're any other person, you commit a high crime, you can go to prison for 10 years, and then after that, you're also disqualified from, I think, running for public office for another 10 years. So that to tell you how serious it is for you to disobey the Supreme Court when it comes to his power of judicial review regarding constitutionality or otherwise. So please read the cases of Ekwam against Pianim, Ekwam against Pianim number 2, NPP against Attorney General, the 3rd December case, NPP against the GBC, JH Mensah against Attorney General, Amidu against President Kufuor, Mensima against Attorney General. And Mensima against Attorney General is on respect of an existing law, that is the subsidiary legislation which was made under the Liquor Licensing Act. And it was demonstrated to be inviolative for provisions of directive principles of state policy. So that was actually struck down. Also look at the case of a Republic against High Court Accra, ex parte Strad, ADO, the interested party. Now, just before we leave, just a few points to tie what we'll be doing now, because we don't want to come back to this topic. Yes, judicial review is a very important tool, just like other concepts like separation of powers, constitutionalism, rule of law. However, there are problems, or there are some challenges or limitations. One, judicial review, it is argued, is undemocratic because it involves a serious restriction on the electoral process, which is central to the theory and practice of democracy. So let's look at the Supreme Court. Let's go to the US, for example, the SCOTUS, the Supreme Court of the United States of America, the so-called 9 wise men. They are not elected. Look at how Trump and his people and the congressmen, the kind of difficulties they had to go through to get elected. They are elected, meaning that the citizens have actually approved the message they sold to them. Just like you may hate Trump, but the fact is people like him. And they are saying that he's the one they want to rule. So they voted for him massively. So impliedly, the message that he sold, the people are saying that, yes, we're giving you approval. That's what we want to be governed by. Now, so that is democracy. But then you come to judicial review, you have Supreme Court who are only appointed, they are not elected, and they are not accountable, so to speak, to the electorate. And they are given the power to strike down laws which these popularly elected representatives or politicians have made. So that is the challenge. And again, it is also said that when elected people, they manage or mismanage the affairs, they are answerable to the electorate through the election system. But as we've indicated, what those who are in charge of judicial review, they are not. And again, democratic battles are not won in the courts, but in the legislature and arenas of public opinion. For example, as whether there should be abortion or there should not be abortion in the US, you put it up for election. Majority of people say that abortion should be regulated. That's it. So it's not a matter of letting the court decide, or just as maybe like Ghana, for example, this LGBTI thing is not a matter of letting the court decide. Let the public put it to vote and let the public tell their position, whether they think that it should be this way or that way. So democratic battles are not won in the courts, but in the legislature and arenas of the public opinion. The judiciary is not accountable to anyone, so to speak, only accountable to itself. So another question is whether judicial review negates the concept and application of separation of powers. Does it not tilt checks and balances ambit in favor of the judiciary if we look at it? Well, these are matters we have to ponder. Now, judicial review is pursued by deployment of appropriate remedies or solution. In other words, where you have made a determination that a legislation, for example, is in violation of the Constitution, or a subsidiary legislation is in excess of the legislation, or a certain authority exercise is illegally exercised or travaris. Once you've made that, you need to remedy the wrong. How are you going to remedy it? You make use of these tools, mandamus, by which you question, you compel, the person who has given the legal authority. If you're, like someone has a legal authority, the person is not exercising the authority, and you are affected. Mandamus will be issued to direct him to exercise the authority. Prohibition will be issued to restrain a person who is, for example, committing illegality, or who is violating maybe a right of natural justice or some other thing. Then co-warranto, by what authority are you acting? And also certiorari, that is to quash, nullify the decision or the action that you've taken. And then the habeas corpus, to order you to show cause why the person you are detaining should not be released. And of course, injunction, as you know, to restrain you from doing something which is illegal. Judicial review, I think because of time, I will just may have to come back and have a short class to finish this. Otherwise, I'm just rushing through for you. So I'll pull the curtain here. And if you have any question, I will take it